I want to draw your attention to one thing, ladies and gentlemen. I am now live streaming. I was not live streaming earlier, your jury selection. And that is, because your place on the jury is, I don't make that public. So I do want you to assist me if there's a time during the trial that, I have you leave the courtroom. What you see in the bottom screen is what they see on the live stream. So if I get ready to ask you to leave and then that camera, is not pointed to the floor, the officers should bring it to my attention, but if we don't, just say, judge, our faces. So it's my intention not to show your faces on YouTube. Okay. I am starting the jury instruction with 2.2. I will now explain some of the legal principles you will need to know and the procedure we will follow in this trial. A trial follows this procedure. First, the prosecutor makes an opening statement where she gives her theory about the case. The defendant's lawyer does not have to make an opening statement, but she may make an opening statement after the prosecutor makes hers, or she may wait until later. These statements are not evidence. Are those the pads for the jury? I need the pads and the benefit fees. I forgot, I'm sorry.
Nope. You want me to hand them out now?
No, you can hand them out after I give my instructions, but they also need fees. Next, the prosecutor presents her evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has the right to cross-examine the prosecutor's witnesses. To prove the charges, the prosecutor must prove the following beyond a reasonable doubt. First, that the defendant was in a tavern, grocery store, business place, manufacturing establishment, street, lane, alley, or highway, or public building, at a park, and an election, a public meeting where people were lawfully assembled. Second, that the defendant intentionally engaged in conduct that threatened public safety, threatened violence to other persons, disrupted the peace and quiet of other persons, interfered with the ability of other persons to perform legal actions or duties. Those are options. They don't all have to be proven. The defendant must have intentionally engaged in conduct that went beyond stating his position or opinion or the mere expression of ideas. That the defendant was in a place open to the public. That the defendant was intoxicated. A person is intoxicated when he or she is mentally or physically impaired as a result of consuming an intoxicating substance, such as an alcoholic beverage or other substances. Third, that the defendant directly endangered the safety of another person or property, disrupted the peace and quiet of other persons, or interfered with the ability of other persons to perform actions or duties permitted by law. After the prosecutor has presented all of her evidence, the defendant's attorney may also offer evidence but does not have to. By law, the defendant does not have to prove his innocence or produce any evidence. If the defendant does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all of the evidence has been presented, the prosecutor and the defendant's lawyer will make their closing arguments. Like the opening statements, these are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about the evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide the case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all of the evidence and all of the testimony, and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each witness said. What you decide about any fact in this case is final. When it is time for you to decide the case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. It is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or a part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you have based on the race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth, or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence?
Yes.
The questions that the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think something is true just because one of the lawyers asks questions that assumes or suggests that it is true. I may ask some of the witnesses questions myself. These questions are not meant to reflect my own opinion about the evidence. If I ask any questions, my only reason for doing so would be to ask about things that may not have been fully explored. During the trial, the lawyers may object to certain questions or statements made by other lawyers or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my own opinions about the facts of the case. Sometimes the lawyers and I will have discussions out of your hearing. Like this morning, we went in the back hall. Please pay no attention to these interruptions or discussions. You may not discuss the case with anyone, including your family or friends. You must not even discuss it with other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should decide the case Then you should discuss the case among yourselves, but only in the jury room and only when all of the jurors are present. When the trial is over, you may discuss the case with anyone. Although we do expect the case to conclude today, I'm gonna still read 2.13, recess. If I call a recess during the trial, I will either send you back to the jury room or allow you to leave the courtroom on your own and go about your business, but you must not discuss the case with anyone or let anyone discuss it with you or in your presence. If someone tries to do that, tell him or her to stop and explain that as a juror, you are not allowed to discuss the case. If he or she continues, leave and report the incident to me as soon as you return to court. You must not talk to the defendant, the lawyers, the witnesses, or my staff about anything at all, even if it has nothing to do with the case. It is very important that you only get information about the case in court when you are acting as the jury and when the defendant, the lawyers, and I are present. You may take notes during the trial if you wish, but of course you do not have to. If you do take notes, you should be careful that it does not distract you from paying attention to all of the evidence. When you go to the jury room to decide on your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the other jurors see them during
Oh,
deliberation.
good Lord. I didn't
You
know I'd
must
remember
turn
that.
them over to the court officers during recess. Your notes will not be examined by anyone. And when your jury service concludes, your notes will be collected and destroyed. You can see that we have chosen a jury of 8 after you have heard all of the evidence and all of my instructions. We will draw lots to decide which 2 of you will be dismissed in order to form a jury of 6. Possible penalty should not influence your decision. It is the duty of the judge to affix the penalty within the limits
All right, it's a
provided
small
by
case.
law. I may give you
We got a
more
panel of
instructions
6.
during the trial, and at the conclusion of the trial, I will give you additional detailed instructions about the law in this case. You should consider all of my instructions as a connected series. Taken all together, they are the law that you must follow. After all of the evidence has been presented and the lawyers have given their arguments, you will go to the jury room to decide on your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. It is important for you to keep an open mind and not make a decision about anything in this case until you go to the jury room to decide the case. The court has concluded its preliminary instructions. Are the people satisfied with the court's instructions? Is the defense satisfied with court instructions? Are we ready for opening statements?
People are ready.
Ladies and gentlemen, I am going to give you notepads now. If you take notes right now, well, I would rather you not take notes right now. But if you do write something down, make sure, you should have a number on the top of your jury, on the top of the pad. Is there a number? Make sure you have the correct number.
Here we go, people.
They should have passed them out by numbers. So
Let's
make
get
sure
ready to
your
rumble.
number coincides with your jury number.
Let's get ready to run.
Okay? If you take notes right now, please mark it opening statements. Please remember that opening statements are not evidence. They are just a guide. And then if you take notes during closing argument, again, mark it closing argument.
By the way, I've heard all your complaints about the glove boat being too loud.
So ladies and gentlemen.
To all you whiners,
I introduced myself earlier today. My name is
I have this to say.
Exciting and new.
Will be on a reasonable doubt that on June 18th of 2023, officers were called to a residential street, Stokel in the city of Detroit, upon a notice assault. When the officers got there, they came into contact with the defendant, Mr. John Clark. Now, ladies and gentlemen, I know during voir dire you all heard a lot about how a person looks when they're intoxicated, what a person will have to, what an officer or a reasonable person will have to prove to show that somebody has been drinking or been intoxicated. But ladies and gentlemen, what I'm gonna ask you all is to listen to the evidence. You'll hear from testimony of Officer Law, who was the responding officer to the street, Stokel in the city of Detroit. And he's going to testify as to what happened when he arrived at his home and his observations of the defendant, Mr. Clark, when he arrived at his home. Ladies and gentlemen, the people also tend to prove through video the observations that Mr. Clark, Officer Law, was testifying. And ladies and gentlemen, one thing I want you to keep in mind is that, like the judge said, anything that I say, since the counsel says, or the court says, is not evidence. Okay? So anything I'm saying right now is not evidence. I'm asking you all to take a look at the And you all can, or you all said earlier in the year that you all would be able to be fair and impartial. And that's all I'm asking. But you look at it and determine what the theory of the people is. And that is that Mr. Clark was a resident, who was a family resident, who was outside on the public street, and for public sidewalk. And just his demeanor and his disposition at the time he interacted with us. Now, ladies and gentlemen, while you're listening to the evidence, I also want you all to keep in mind that sometimes the law
And also,
is
if
set
you
in
do,
place for public policy reasons. And when you look at the jury instructions, I want you to keep in mind that everybody in the neighborhood has a right to peace and quiet. Everybody in the neighborhood has a right to enjoy the peace and quiet and not be disturbed by any outside disturbance going on in the neighborhood. I also want you to keep in mind that the public policy reasons for some of these laws that are set in place is to protect the safety and the concerns of the people in the neighborhood, whether they be your next door neighbor or your family member or whoever. But I want you to keep in mind that there are public policy reasons for some of these laws that are set in place. So again, ladies and gentlemen, I'm asking you all to keep an open mind as you all stated that you want to go here and listen to the evidence and listen to the testimony. And once you all do that, you all will return the verdict for guilty. Count one of this ordinary person. Thank you.
Will the defense be making an opening at this time?
I didn't even,
Yes,
Okay, you may.
thank you, ladies and gentlemen, and for your patience and understanding.
I didn't hear any of that.
It is one of the
Sorry.
fundamental rights that we have as Americans, and I know a lot of people don't like it, but I cannot stress to you, I've been doing this for 27 years, how important it is for a fair and impartial jury counsel. Trusting you and the answers that you gave in 1 year to do that, and do that. In regards to the people's case in chief, what you're going to hear, and in my opinion, I'm going to tell you what I believe the testimony is going to be, that you're going to hear. And why I believe that testimony will be sufficient to really find beyond a reasonable doubt that Mr. Clark is guilty of the charge as stated by specifically back in June, the one that's saying June last year, while people try to, well, you're going to hear testimony that the police were called to a residence. That police, when they arrived at the residence, they saw family members outside of the residence on the sidewalk in front of the house of the family residence. And Mr. Clark is a part of that family who owned that house. So in regards to it being a public place or anything besides the sidewalk in front of your house, and most of you as employers know that that sidewalk is what you have to maintain, part of your residence, not a part of the public. So let's just be clear about that fact. And then we go to what the police or Officer Law actually observed. I don't know that a video will necessarily be played, or audio will not. I believe the testimony of Officer Law should be sufficient in what he observed, which is family members outside of family house talking, discussing whatever they're discussing, that based on what he had received in regards to going back home, that Mr. Clark was the object of someone's ire or irritation or something. That he walked with Mr. Clark, talked with Mr. Clark, I believe this is the one that walked with Mr. Clark, and that there was no issues as far as Mr. Clark was concerned. That the officer did not see Mr. Clark acting in such a way to endanger himself or anyone else. That while they didn't the whatever the reason for the officers to appear, that officer didn't observe didn't see any disturbance that is a threat to Mr. Clark or anyone else. Further, I believe that the testimony is going to state that that officer did not give any sobriety tests. That that officer did not take any breathalyzer or get any blood tests in regards to intoxication. And when I look at the jury instructions and hear the testimony, I do not believe beyond a reasonable doubt. And I thought the court was going to kind of go into beyond reasonable doubt, but beyond a reasonable doubt on each and every element as instructed in the jury instructions. I thank you for your attention and your dedication. I believe that you will find that Mr. Clark is not guilty.
All right, on behalf of the people,
This time, members would like to cover first.
you may,
Deputy Mayor would like to call Officer Caleb.
okay?
We're all pulling for this, and you know it.
Ma'am, are you a whore?
I object to the relevance of that, Your Honor.
All
right, what,
I'll tie it up real quick, Judge.
all right, go ahead.
You're not a whore?
Officer, step towards me and raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, help you God? All right, officer, you may be seated. Officer, I don't know if you can testify in court at 36 District Court, but the mic sticks up, and so just, adjust it where we can hear you. All right, you may proceed.
Thank you, Your Honor. Good afternoon, Officer Law.
Good afternoon.
Officer Law, can you state your name again for the record, please?
Officer Kalen Law,
Thank you, Officer Law. And Officer Law, where are you employed right now?
for the city of Detroit,
Okay. And what do you do for the city of Detroit?
police officer,
Okay, how long have you been employed as an officer for the city of Detroit?
9 months now.
Okay. And Officer Law, I want to take you back to
Come on, people.
on or about June 18th of
Show the witness.
2023.
Trying to
You
strain
recall
you.
being dispatched to a street called Stokel
Yes, ma'am.
on that day?
Yes, ma'am.
And is that within the city of Detroit?
Yes, ma'am.
And is that the county of Wayne?
Yes.
Okay. And do you recall why you were dispatched to that location?
For felonious assault. and private assault.
Objection, Your Honor, that would be hearsay. You'd say that he had a run, but in regards to the definition or description of that run,
Counsel. As much as you can, no speaking objection. So the objection is to hearsay. Ms. Ritter, what's your response?
That is not hearsay, Judge. I'm not asking for a statement made by the clerk out of court. I'm asking him why he was dispatched to that location.
Overruled.
Thank you. So again, I'm sorry, Officer Lawson, you repeat let me repeat my question. Why were you dispatched to that location?
I was dispatched there for felonious assault. and
I don't
private
know.
assault.
I asked that
Okay,
same
and can you
question.
explain to the jury what a felonious assault?
Felonious assault is an assault that takes place where there's a weapon involved, potentially a firearm or a blunt object used against a person.
Okay, and, were you alone or were you with someone?
I had a partner that day.
Say that again.
I had a partner that day.
Okay, do you recall who your partner was?
Yes, Officer Warren,
Okay, and were you the driver or the passenger of the vehicle?
passenger.
Okay, and can you explain to the jury what you were wearing?
That day I had on a Class B uniform, buttoned up shirt with our name and badge numbers on, and pants as I have on today.
Okay, and can you describe the vehicle that you were in?
I was in a fully marked scout vehicle, light sirens, emblem. All the time.
Okay, and, were you with anyone else when you came to that location?
We arrived first and then the supervisor arrived shortly after.
Okay, when you say we, who are you referring to?
Officer Warren.
Okay, and, can you describe to the jury what happened when you first approached the location?
When I first approached the location, I seen a large group of males holding back another male.
Okay, and where, if you recall, where was this large group, at when you came to that?
It was probably a house down from where the address of the location we were responding to. It
Okay,
was an empty fence, like a gated fence, but another house would have been there.
okay, so as you're describing to the jury, it was in front of an open field?
Yes, with a fence, it was a fence right there blocking the field between us and the sidewalk.
Okay, and when you say open field, was there a house in there?
No, ma'am.
Okay, and did you approach, this crowd, or did your partner approach this crowd?
I approached.
You did, okay. And what happened when you approached this crowd?
I obviously seen him holding back one male, seemed very irate.
I'm sorry.
Yeah. One male seemed very irate, and I made contact with him to see what was going on.
Okay, so let me just stop with this one minute. Let's go back just a little bit. When you say a crowd, you recall how many individuals were a part of this crowd?
No, ma'am.
Okay, the person that you said that you observed that this person was acting irate, is that your testimony?
Yes, ma'am.
Okay, and you see that person in the courtroom today?
Yes, ma'am.
And can you point them out and tell me what they're wearing?
Green sweater, light complected male, brown boots.
Okay, judge made a record reflect identification of Mr. John Clark. The record reflect identification of Mr. Clark. Thank you. And what, if anything, did you observe about Mr. Clark? Can you explain it to the jury?
Yeah, like I said, he was visibly irate, and he just continuously other males that was around was like, he tripping. That's what they were.
Objection of hearsay, Your Honor, and you would ask the officer.
Objection, hearsay, what's your response?
Judge, may I rephrase the question?
You may.
I'm sorry.
So
So
you would
without,
ask for it to be stricken.
may I proceed? Your Honor? Thank you. Officer Law, without telling me what anyone said, just your observations of what you saw, can you explain that to me very please?
Yeah, the male was visibly irate, and there was a bunch of yelling going back and forth between both parties and everyone involved.
Okay, and that's still within this crowd that you're describing?
Yes, ma'am.
Okay, and, is there anything else you observed about Mr. Clark when you approached?
Yes, ma'am. I observed his shirt kind of pulled up in a holster on his right hip.
Okay, if you can stand up and kind of, demonstrate what you're demonstrating.
His shirt was pulled up like it was involved in a certain altercation. It's holster inside the waist down. It was a holster that was in.
Okay, now, you can go ahead and sit down, I'm sorry. Now, when you say this holster was on his waistband, can you describe if it was inside the waist, band or outside?
That, I don't really remember whether it was inside or outside, but it was a holster that didn't have anything in it at the time.
Okay, you can see that from your observation.
Yes, ma'am.
Okay, so what did you do, without telling me what anyone said, what did you do after you observed?
After that, we pat him down.
I would just ask, I'm sorry, Your Honor, I'm going to object and ask that the officer refer to himself as opposed to him or someone else who's not present, or may not be present testifying.
Yeah, Officer Law, just try your best. I know sometimes it's hard, but try your best to say what you did and not what collective was done.
Yes, ma'am.
Thank you.
Yes, ma'am. I pat him down.
Okay, and did you, and let me go back. While you were patting Mr. Clark down, did you notice anything else about Mr. Clark's, physical appearance?
Slurred speech, stumbling in a manner, not really necessarily, I wouldn't say stumbling, just unable to keep his balance, and slurred speech while pointing.
Okay, and, what happened after you, pat down Mr. Clark? I'm sorry, after you patted down Mr. Clark?
From there, I detained him due to the nature of the run and him being described as the subject that we were responding to that location for. And from there, I don't really recall whether I put the vehicle immediately or left him outside the vehicle until I further investigated.
Thank you. And you did, according to your testimony, you're indicating that you did do further investigation.
Yes, ma'am.
Okay, did you have, without telling me what was said, did you have any other discussions with, Mr. Clark personally? did you have any discussions with Mr. Clark?
Yes, I did.
Okay, and can you describe, what you observed during those, I guess during that conversation with Mr. Clark? Without telling me what was said, can you describe, anything that you may have observed?
It was a bunch of bargaining.
And can you describe?
I didn't hear that.
It was a bunch of bargaining. The conversation was bargaining.
Okay, and when you say bargaining, can you describe that to the jury? Without telling me what was said, can you describe what you mean by bargaining?
By bargaining, I mean, if you do this for me, I'll do this for you.
Okay.
Conversation.
Okay, and did you have any, without telling me what was said, did you have any other discussions with anybody else, part of this group or anyone during their investigation?
Yes.
Okay. And after those discussions, what happened?
From there, a call for a supervisor to make the location. The supervisor made the location. And Mr. Clark was put into the back of our scout.
Okay, and why did you call, if you recall, why did you call the supervisor to come to the location?
Due to the nature of the run, and not only that, the area that we were in, and there was another male that was down the street from the location who didn't have anything to do with it at all, who was causing a disturbance as well.
Okay. And did you observe anything else, going on while you're doing this investigation?
No, ma'am.
Okay. Judge, may I have a moment?
You may.
Thank you. And at this time, I would like.
Does anyone know what's going on yet? I can't hear enough. There's bargaining, there's third speech. That's all I know.
If the prosecutors attempting to show the video, there's been nothing in regards to impeachment or anything else that the video would be applicable.
In the house.
I don't understand the legal basis for your objection. I'm gonna overrule it. You may share the screen.
If we could approach your own.
Sure. Do you like it?
Oh, we get video. Life is good. Finally.
In the front room?
Things are heating up. It's getting hot in here. Play us a video. That gets me excited. And then you know what happens, don't you?
Love, exciting and new.
I don't like this video. It's not very exciting. Oh, we got a sidebar going on? I mean, I can't hear the court very well, and then someone keeps playing the Love Boat theme and blowing my ears out, you know? It's very problematic on the stream.
May I proceed, Your
You may.
Thank you. Officer Lark, can you see the monitor in the courtroom?
Yes, ma'am.
Okay, and Officer Law, there's a still shot of a picture on that screen. You recognize that still shot?
Yes, ma'am, that's my right arm.
Say that again?
Yes, ma'am, that's my right arm.
Okay, I see two arms. Can you describe which arm is yours?
Right one with the tattoos on it.
Okay, and what is that a screenshot coming from? What still shot is that?
From myself and my partner putting the subject into the back of our scout.
Okay, let me rephrase my question. What is that screenshot of?
Of the vehicle?
Okay, on that day, were you wearing any body worn camera?
Yes, ma'am.
Okay.
We
and is
didn't
this
agree
the
to the
pic
foundation
of
on
what
this
your body
thing.
worn camera was captured on that day?
Yes, ma'am.
Okay, and since you have turned that back, I'm so, let me jump back. I know myself. Do you turn in your
Oh,
body worn camera
Let me see.
to
Does this,
your
does this
supervisor?
Yes, ma'am. Whenever I
Exciting
take the
and new.
camera back into the armory.
Okay, now, since you have returned the camera, from your point of view in the courtroom, has this been changed or altered in any way? Turn the camera.
No, ma'am.
Okay, Your Honor, at this time, people will submit people exhibit one to evidence.
And we would object, Your Honor, there has been no testimony or any other reason. It's cumulative at this point, and without more, just to say, well, I got a body camera, so I should be able to show it, is not appropriate to say,
okay.
well.
He's fighting admission of it, that's
The
why.
wrong speaking objection.
And we would say that it's inadmissible at this time without foundation.
Ms. Ritter, what is the response to the objection?
I'm sorry.
What's the response?
What was the legal basis? So what counsel is doing?
I believe it's like a
Okay, as to the legal basis of lack of foundation, Your Honor, I believe that Officer Law testified that his arm with the tattoos on there. He testified that he was wearing body.
I apologize, I don't think it was a foundation. Ms. Taylor Coleman is saying that while that may be his body cam, you haven't shown a reason that is needed. She said it's cumulative. That was her cumulative. I apologize.
I'm sorry, Judge, the people's response was that this shows that the testimony that Officer Law has given to the court is on the cooperating Officer Law has testified to. So that's him wearing a body worn camera. I'm sorry, I don't mean to make speaking just, but. it's
Well, your
corroboration.
response can be, if I ask you for a response, but
It's
I
corroboration.
just want y'all to shorten up. Yeah. Hey, I'm sorry.
It's corroboration to the testimony from Officer Law.
I'll allow it.
Thank you.
Well, I apologize. I'll allow it subject to the previous, ruling by myself with respect to the body on camera.
Understood, Your Honor.
Okay,
And at this time,
I'm
Whatever.
sorry, Your Honor, corroboration. The response is corroboration of.
counsel, let's approach, because my ruling is that the body worn camera is admissible.
Would you like to say?
Yeah, so if there's,
I think this is actually a request. We're gonna play this thing. So I've been waiting for. We've got us some video, people.
Thank you. Without the article, of course.
Trial.
Ma'am, are you a whore?
I'm sorry, Judge, now you may.
You're not a whore? Not a whore? You're not a whore?
I never want to hear it again. Sweet Jesus.
We would ask that it, for sake of cooperation, that it start at the beginning as opposed to at any middle point for the factual basis.
You may proceed. Thank you, Your Honor. At this time, people like to play.
Yeah, hit play.
Why do y'all make it something that, boss?
Cause 266 K. I am the IT tech for DPD. Yeah. This is what I showed you.
Right.
Headquarters, this, that.
Right.
Everything's good.
Right.
My father is director. He's a fucking boss, okay? That's my father.
Okay.
We're good.
Okay.
Everything's clear.
No, boss. No, boss. Look. I got to do my job too.
Why are you then?
Let me talk to him. Let me talk to him.
Go over there.
Do my job
Let
too.
me talk to him.
You got it.
Yeah.
I got to do my job too.
Yeah.
You already know how.
Yeah, clear.
So what's going on?
They're fucking acting an asshole.
Huh?
Man, this is family issue.
Family stuff. I know how it go, but
this is my grandma's house. I lost all my grandma dead.
apologize.
On this,
Your
you
loss.
feel me? And it's Father's Day, and that's my father.
Happy Father's Day.
And that's what we
So,
going through.
so family is
So yeah. So I
your kids and stuff.
all this. Yeah. Now I gotta take care of that. I got more kids over here. My son over here, and everything gotta get paid for me.
Right.
You understand me?
I feel you. That's why I wanted to talk to you first.
And at this time, Your Honor, people are stopping the video for me for 58 seconds. I'll stop sharing the screen. So, Officer Law, did you get an opportunity to view the video in court that was played?
Yes, ma'am.
Okay, and from your recollection, is that the testimony that you given in court today regarding your encounter with Mr. Plus?
Yes, ma'am.
Okay, and one last question, Officer Law. In the video, Mr. Clark, you and Mr. Clark were standing in front of this field. Do you remember, if you recall, where this field was opposed to the house? That was the question.
Yes, ma'am. That field was to the left of the house.
Okay, so you're
So
talking to me, can you describe what you mean to the left of the house?
it was to the left of the house. So if I'm not mistaken, that field was on the south side of the address. So the house was facing west. That field was on the south side of the address.
I have one over here. You may. No further questions. Your Honor.
We would ask to be able to play video from the beginning of the officer without audio. We would easily without to take the audio off.
Okay, no question. Okay.
Before we show it, I just want to get prepped upon the screen. I will cross-examine. Thank you. Officer Law, at the time of this incident, you would have just been starting or graduating from the police academy.
Yes, ma'am.
How long have you actually been an officer?
June 18th, approximately somewhere between 2 to 3 weeks.
And when you appeared at this location, it was not for a drunken person or that was not the run, is that correct?
No, ma'am.
And you made a report about this incident. Is that fair to say?
Yes, ma'am.
And that report, while it doesn't say everything that occurred, it said what you felt was important in regards to the incident that you observed. Is that fair to say?
Can you elaborate on that, ma'am?
Ms. Ritter, can you stop sharing screen?
Your report,
Yeah, can you rephrase the question for me, ma'am?
as you were instructed in the academy, you guys have to make a report. Is that fair to say?
Yes, ma'am.
And that report should encompass the things that you felt were important about your police run. Is that fair to say?
Yes, ma'am. Anything I observed?
And that's what you put in your report that day.
Yes, ma'am.
You had an opportunity to review that report before this trial, is that correct?
Yes, ma'am.
And nowhere in your report did you say that you observed Mr. Clark with slurred speech or an uneven gait or falling down or anything like that. Is that fair to say?
Yes, ma'am.
But here, some 9 months later, now you're coming in court. Now that's what you want people to believe you saw.
I'm just here to answer the questions that are asked. And
And you spoke with the prosecutor in regards to what this case is about, what your testimony should be. Is that fair to say?
I spoke to the prosecutor, yes, ma'am.
And you would agree with me that in your report, you stated that Mr. Clark said there were no problems, just a family dispute, correct?
Yes, ma'am.
You would agree with me that your report about the incident, and it was written very shortly after this incident occurred, correct?
Yes, ma'am. That
That
same,
9 months ago.
that same day, yes, ma'am.
Yeah, so in regards to your memory and what you saw and what you observed, your memory would have been better at the time that you wrote the report than some 9 months later about the details of this incident. Would you agree?
There are some things that I remember farther along the line.
You didn't supplement your report further along the line in regards to what you remember. Is that fair to say?
Can you rephrase the question, ma'am?
You did not supplement, add to, increase, file a new report in regards to your memory being improved or things you may have forgot
No, ma'am.
back 9 months.
No, ma'am.
And you had never seen Mr. Clark before that day, is that correct?
Say it again, ma'am?
You had never seen Mr. Clark before that.
No, ma'am.
You don't know him,
No,
don't interact with him,
no, ma'am.
don't know what his regular day is or anything like that.
No,
And
ma'am.
in regards to seeing him since that 9 months, you haven't, have you?
No, ma'am.
Do you remember everybody besides me? Who else would you pick out in regards to being the individual that you saw?
You saying, what's the question?
In regards to your identification, you don't know him, you haven't seen him in 9 months, and there's nobody else in this courtroom. So who else would you identify as Mr. Clark?
I vividly,
Repeat your answer.
I vividly remember Mr. Clark.
Nothing in your report describes Mr. Clark physically, is that correct? In regards to your vivid memory of
No.
Mr. Clark?
No, ma'am, nothing in the
There was
report.
nothing that stood out physically about him from any other black male that you've come across in regards to your work as a police officer?
No, ma'am, not in the report.
You're not a horse? Not a horse? You're not a horse? I never want to hear anything. It gets worse.
There were drugs involved that were given to me that ended up being
on his meter. Jump 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 on his meter.
Can you just let this go for once? For once? Once?
Okay, that dude knows.
With his level. 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 With his level.
I never want to hear it again. You a whore.
Mr. Sharps.
Not a whore.
Mr. Sharps. Mr. Sharps. Mr. Sharps. With his level.
You're not a whore.
With his level.
You're not a whore.
With his level.
I never want to hear it again.
With his level.
You're not a whore.
With his level.
You're not a whore.
With his level.
I never want to hear it again.
Now, if anybody thinks this is okay, I am in the wrong group.
All right, I've got it. We're a little behind live, so I've it at 1.5 speed. I don't know what they're doing now. Jurors are getting water. Okay.
Oh, I apologize. Okay, not yet. Hold on.
Okay, thank you. Thank you. Thank you.
My last question was in regards to, you said you vividly remember, Mr. Clark. However, in your report about things that were important, nothing is stated in regards to his physical vividness for you. Is that fair to say?
Yes, ma'am.
And you didn't observe any felonious assault in progress, is that correct?
Not upon arrival.
After your arrival, did you observe any?
No, ma'am. So that was the nature of the call. That doesn't necessarily mean that that actually had took place.
But when you arrived, you didn't see anybody being threatened, is that correct?
No, I just seen a group of people holding back another male.
Did you understand my question?
Yes, ma'am.
And so I'm gonna ask you specifically, I'm going to try to narrow my question so that you can answer
Yes, ma'am.
for what I asked.
Yes, ma'am.
Okay. And you don't recall about this crowd, is that correct?
Say it again.
This crowd, you don't recall the number.
No, ma'am.
The crowd, is it more than two, is it three, what?
2 or more.
Two or more is a crowd. And you don't know if all of those individuals were family members for a family Father's Day celebration, is that correct?
No, ma'am.
You don't know.
If they were our family at that moment, no, I do not.
You don't have any information that it was just a public crowd, is that correct?
No, ma'am.
That's not correct.
You saying it's a public, can you
That there was
repeat your question?
A group of just public people standing outside of this private residence.
It was just a group of males talking back another male.
You don't know if that,
There's objection and action against it.
if that group of a number of males, 2 or more, was just a group of public people walking down a street or anything like that. Not a public event, like an event at a park where people gather to celebrate something. You don't know that to be those individuals, is that correct?
That question, like yes or no answer would sum up the true answer to that question, though, if I say yes or no to that.
You don't understand my question, exactly.
No, I understand your question, however, the question, a yes or no answer to that wouldn't sum up the full answer of that question.
Can you say yes or no? You don't
Can you
know
repeat
if that crowd was from a public event, maybe just a public event in some way. You don't know if those individuals, 2 or more individuals, was from some public event, is that correct?
No, those individuals knew the subject and were vividly yelling back at the people at that residence where the nature of the incident took place.
Did you understand my question? I didn't ask about anybody yelling or anything like that. I asked if you knew.
But can you rephrase the question, ma'am?
Do you know if this was a public event at this home?
No,
And in regards to this open field, isn't it true that that open field was a part of the property owned?
Objection, Judge. That causes speculation.
I can ask anything else. Okay. Rephrase it. You don't know if that public field or the open field, as you said, belonged to
We
the
have no idea,
residence
Chris.
in which the 2 or more people were standing, is that correct?
no, ma'am,
You don't.
no.
So you don't know if it was part of the private residence, is that correct?
The field?
Yes.
No, ma'am, I don't know.
But you didn't see Mr. Clark in the street when you approached, isn't that correct?
No, ma'am.
You saw him on the sidewalk.
Yes, ma'am.
In front of his private residence, is that correct?
Unsure if that field was, who the field belonged to, so he was on the sidewalk.
Yeah, there's a link to Bandcamp. I'll hunt it down right now.
And nowhere in your report did you say that Mr.
Thank
Clark
you.
was irate from 9 months ago, is that correct? I apologize, Council, repeat your question. Nowhere in your report did you say that Mr. Clark was irate, isn't that correct?
Ma'am, can I refer back to my report?
Please.
I didn't get to speak.
I did. I got this report from you.
From your desk.
Yeah.
I'm ready to play now. And you may repeat your question too,
Nowhere in your report does it say that Mr. Clark was irate, is that correct?
not by my personal observation, no.
Thank you. And so it's not written in your report.
Family members that were at the location.
I'm sorry, my question was, it's not written in your report that Mr. Clark was irate, is that correct?
Family members that were spoken to.
I'm
stated
not
that.
asking you, Officer
So
Long.
can you rephrase it for me, then, ma'am?
Nowhere in your report 9 months ago did you write the words that Mr. Clark was irate, that you observed Mr.
No, ma'am.
Clark? Thank you. You didn't take any sobriety tests of Mr. Clark, is that correct?
No, ma'am, I didn't.
You did not take a breathalyzer test of Mr. Clark, is that correct?
No, ma'am, I did not.
You did not get a blood draw of Mr. Clark, is that correct?
No, ma'am, I did not.
If we could play.
Council, before you play, can you all approach about that? Come on, this side.
Exciting and new.
Okay. Oh, I'm sorry. You said all audio is off. Oh, that was recorded.
Right, yes, okay. Okay, Ms. Ritter, you may share from the,
Oh, I'm sorry, there's one other statement before we share.
okay.
Nowhere in your report do you state that there was bargaining by Mr. Clark or anyone else, is that correct?
No, ma'am.
Okay, you ready?
Ready?
Okay, Ms. Ritter.
Play again.
You may, yes, with no audio. Ladies and gentlemen, they're gonna play this video starting at the beginning. However, in the beginning, the court has already made a ruling that the conversation, I guess I would say, in the beginning of the video is not admissible. And so you can watch the beginning, but you can't hear it.
These knees are breaking the case open for me personally. I don't know about you guys.
Yeah, let's just play it from the beginning. How long, where did you start the video from? 4 minutes?
It was about 3 minutes and 30 seconds.
Okay, yeah, it's not that long to get to what you're trying to get to. It seems long, because it's not that long. You all keep watching that, I'm sorry.
We can pause right there. Right here on your body cam, you see approximately 3 people. Would that be fair to say? Well, right here we see 2 people, but there was another individual on the other side. Do you recall seeing that?
Yes, ma'am.
And so when you say 2 or more as a crowd, that's a fair, accurate representation of what you saw on that day.
Yes, ma'am.
You continue playing. I'm sorry, can you see?
I'm sorry, this is the chair.
I know, you can, you might need to stand up, yes, sir. Yeah, and the plexiglass doesn't help, so. Pause it for a second, so. You're welcome. Okay, do you need to rewind it a little bit? Okay, just rewind it a little bit.
And actually, stop, pause, I'm sorry. Actually, it's just those 2 that you walked up to in that part of your body cam. Is that fair to say? Did you see that?
This is an individual standing behind.
Stop. You see those 2 individuals?
Yes, ma'am.
And the person that's walking on the other side, is that your partner?
I can't see.
Yeah. Yes, please. You don't know who that other is.
So if you pause, the original 2, when I walked up, if there's another set of shoes, in fact, there are white shoes back there, and obviously we can't. So there was another individual.
Okay, so it was possibly 3 individuals. Is that fair to say?
I said 3 upon, including the subject, or you saying 2 I was holding back. So
I'm sorry, I didn't see anybody holding anyone back in your body cam. Where did you observe someone holding someone back?
the male that's in front of our camera view right now,
You're saying he's holding them back?
if you can play the video back, you can't, I was saying,
Yeah,
it's
right.
I'm sorry, can the officer see?
I guess so.
Can you see?
Yeah.
Okay.
All this plexiglass still here, I don't know.
And we're walking.
right there. He's holding them back right there. And once more, he snatches away from the center.
You're saying that you can look at this and you're that,
Did you want this?
yes, please. Thank you. You're saying that this looks to you like this individual is holding back that individual. Is that your statement today?
He's keeping the barrier.
My question is, you're saying it's looking right here that you believe that this shows that this individual is holding back that individual. Have you continue playing it?
It kind of looks that way to me.
Please
I
stop.
don't think it's a good line of questioning.
Thank you. And that individual walked around to come to you, the police officers, is that correct?
Yeah.
Didn't run away. The individual you're stating is Mr. Clark. Didn't, you didn't see him hit anybody or anything like that. Is that fair to say?
No, man.
Okay. but approached you, police officers, as you're doing your investigation. Is that fair to say?
Yes,
Yes.
I guess, okay, yes. And you received. Counsel, I'm gonna interrupt you. Well, approach before I ask this question. So, but you go ahead. Well, I'm sorry. Come back one more second. Oh. You go ahead.
Finally, nowhere in your report did you state that you observed Mr. Clark, endangering the safety of another person or property. Is that correct?
yes, ma'am.
Nor did you observe him disturbing the peace and quiet of other persons. You didn't observe him because you don't know what was going on before you got there.
I didn't deserve him to serve the peace.
Thank you.
Ms. Ritter, you do have some redirect.
I do.
Okay, ladies and gentlemen, I'm trying my best to keep my word. I'm trying. So I have a question. Oh. All right, Ms. Ritter, redirect. Does anybody need water? Okay, let's get some water and then maybe let's go ahead and turn the fan on a little bit. Get a little breeze going of some sort. I don't know if we can move it closer to the jurors. Is there a plug over there by the jury box, over there anywhere? Maybe we can put it over there. Madam Officer, somebody, I think two people need water.
Oh, sorry, I was trying to get your attention right there. You know.
All right. Okay, Ms. Ritter.
Thank you. Also, I just have a couple of questions for you. So, at this point, you testified that you were out of the academy for about 2 or 3 weeks.
Yes, ma'am.
So your training and experience in the academy would, I guess, agree with me, it's still fresh.
Yes, ma'am.
Okay, and during your time at the police academy, did you, learn any training or experience with dealing with someone who is a fighter?
Yes, ma'am.
Okay, and can you tell the jury what some of those things are that you learned?
I'm gonna object as to relevance, Your Honor, where stated specifically in regards to field sobriety, breathalyzer, or anything else he did not do. The relevance of what he learned in the academy, first interacting, especially where he acknowledged in his report, he didn't say anything. It's a long objection about Mr. Clark being intoxicated.
What's the legal basis for the objection?
Irrelevant.
Okay, Ms. Ritter.
Judge, let's go.
Overruled.
Go ahead, Mr. I'm sorry, Officer Law. Can you tell the jury what are some of the things you learned in the police academy regarding, intoxicated or impaired individuals?
Based upon training, I was taught to look at slurred speech, inability to stay in balance, Also, the odor of intoxicants emitting from someone's breath. And, obviously behaviors as far as erraticness and unable to stay on topic pertaining to a certain conversation.
Okay, and during your, observation of Mr. Clark, did he indicate any of those signs to you?
Yes, ma'am.
Okay, and again, can you tell me what those signs were that you observed from Mr. Clark?
One of the signs were the slurred speech, the inability to remain standing in one place, and the inability to stay on topic of whatever the conversation was pertaining to.
Thank you. And based on your training and experience, when you observed those specific indicators, Clark, what did that indicate?
It indicated to me that alcohol was a factor.
Thank you. And going to, I think since the council asked the question of your initial response to the home, you testified it was for this assault, correct?
Yes, ma'am.
And I think, earlier in your testimony to me, you did indicate that you did do further investigation regarding your initial, response to the home, correct?
Yes, ma'am.
Okay, and do you recall, what you may have, discovered during your initial investigation for this dispatch for police assault?
Objection, irrelevant, and after the point, actually not on point at all, but specifically in regards to.
I don't understand, counsel. The basis of the objection is relevance.
Relevant.
Ms. Ritter, what's your response?
That this was the dispatch call for police assault, and there's an investigation. It's called. Thank you. Let me ask this, Officer Law, after, you had your interaction with Mr. Clark, did you talk to anyone else, without saying what they told you, did you talk to anyone else that was at the home?
Yes, ma'am.
Okay, and upon your discussion, without telling you what anyone said, upon your discussion, did that result of anything?
Yes, ma'am.
What did that result of?
Can we backtrack? Can you repeat the question again?
Right, so after your discussion with the person at the home, what did you conclude in your investigation? I'm sorry.
I concluded that an assault took place.
Okay, and how did you conclude that?
I'm going to object, Your Honor, especially in regards to not relevant, but also outside the scope of cross.
Okay.
I have one more to do.
You may.
I have one more to do. I'm sorry.
Yes.
Okay, last question, Officer Law. So, when you initially arrived at the scene, you indicated that there were some individuals that was present with Mr. Clark, correct?
Yes, ma'am.
Okay, and based on your testimony, you said it was 2 or more within this crowd, correct?
Yes, ma'am.
Now, based off your observations, did it look like these people knew who Mr. Clark was?
Yes, ma'am.
Okay, and based on your observations, were there anyone else within that immediate area where Mr. Clark was?
Yes, ma'am.
Okay, and do you know, from your observation, or upon your investigation, I'm sorry, do you know who those individuals were? It's yes or no?
Yes, ma'am.
No further questions.
Nowhere in your report did you state that alcohol was a factor for Mr. Clark, is that correct?
Yes, ma'am.
That is correct.
Yes, ma'am.
Nowhere in your report, some 9 months ago, when you were just seeing this incident, did you state that? Is that statement you're making today?
In regards to,
Your report about the incident and the important things that you observed. Okay.
yes, ma'am.
Or anything else?
Just very quickly. Now, Officer Law, when you made your report, you made your report based off what you were dispatched at location, correct?
Yes, ma'am.
Now, based on, I guess, Berkeley Department policy, are you required to make any supplemental reports to those reports
Only if I found further information upon an investigation,
upon what investigation?
upon the investigation of what we're. If any additional information could help or resolve some missing pieces to whatever the case may have been.
So your initial,
Yes, ma'am.
okay, nothing further.
All right, thank you, Officer Law, you may step down.
Yes, ma'am.
I'm sorry. All right, anything further on behalf of
I have one thing.
you, may?
Nothing further from people have no further.
And the people rest?
The people who read it.
All right, anything on behalf of the defense,
We have no witnesses, Your Honor.
okay, can you take the jury in the hallway just for a moment?
All rise to the jury.
They don't have to go to the jury room. Yeah, leave your notepads in your chair. They don't have to go to the jury room, but, just in the hall. No, go up there. Oh, the fan is right there. Okay, all right, you all may be seated with the exception of defense counsel and, the defendant. Mr. Clark? Sir, your lawyer has indicated that, defense rests. Did you heard her say that? And, Mr. Clark, that means that you have decided that you are not going to testify in this case? I need you to speak up. Correct? And Mr. Clark, do you understand that you have an absolute right to remain silent, but you also have a right to testify if you choose to? Do you understand?
Yes.
And do you also understand that, while you should consult with your lawyer about whether or not you should testify, the decision as to whether or not you will testify is yours and yours alone. Do you understand? In consultation with your lawyer, is it your personal decision not to testify?
Yes.
Has anyone threatened you in any way or promised you anything to get you to come to that decision? Thank you, sir. Okay, you can bring the jury back. You need to work?
Yes.
Okay.
Sorry. Real-
That's okay.
Sorry to dance.
Where are the jurors standing as it relates to
The ladies back.
are they right there by?
The ladies have who's at the other end or on this side.
Okay, you can go ahead. Thank you. And then after she leaves out, you can bring in the jury, but.
Well, I have a motion before you bring it.
Well, then take them to the jury room if she has a motion. No, you go to the bathroom, you take them to the jury room,
just right.
Oh, my goodness, okay. All right, Ms. Ritter, your response?
So now, court is.
Oh, yes, you gotta speak up because of that fan.
I'm sorry, Judge. If the court is looking in light of the non-moving party, I'm gonna ask the court to deny this motion at this time. The people did present one witness, Officer Law. Officer Law indicated that he was dispatched for a woman's assault run to his location on Silver Street. Upon his arrival, he did come into contact with Mr. Clark. At that time, Officer Law indicated that Mr. Clark showed signs of impairment and or intoxication at that time. He was standing in front of the field that was next to the home he was questioning. There was also testimony that there was a couple individuals holding Mr. Clark back, which seems to be that Mr. Clark was irate at the time that Officer Law approached the scene and addressed Mr. Clark. Based off of the testimony from the officer, Your Honor, I believe that looking at the jury instructions, the people have, with this one witness, met their verdict. But not only that, Judge, the people have given the court enough evidence. Oh, and there was a video play, I'm sorry, Your Honor. So with that being coupled with the fact that there was testimony from the officer about what happened to the arrived to the scene, the people believe that the people have enough evidence to survive the defense counsel's motion for a directed verdict. And at this time, Your Honor, I'm asking the court to deny.
Any rebuttal?
Yes, Your Honor, specifically where the officer, so 9 months later, now wants the court and the jury to believe that this was about intoxication. He started off saying this is a felonious assault, but nowhere in his report at the time of the incident did he say anything about slurred speech. Did he say anything about an inability to stand? Did he say anything at all about alcohol in regards to Mr. Clark? This is a case about public intoxication, disorderly conduct. For that to be true, besides whatever he was told in regards to his testimony for today, it lies in the basic reason and common sense that if that stuff was the truth, then why didn't he mention anything? Not just all of it, but any of them in regards to public intoxication. He cannot say that that street or the individuals that were present were a part of a public event, part of a but the elements in regards to a public event or disrupting a public event. He very clearly said he did not see Mr. Clark disrupt anybody. He very clearly said he did not see Mr. Clark do harm to himself or anyone else. These are elements directly from the jury instructions that people have met, regardless of I'm coming to court now. Those are elements that he never addressed. He never addressed, never substantiated. And therefore, the people, the court should grant our motion for directed verdict.
In reviewing a motion for directed verdict, the court used the testimony and evidence in a light most favorable to the non-moving party, that being the people, and people would have to show the court that they have created a question of fact for the trier of fact. In a manner tried by the jury, some of the issues that counsel has raised are questions of fact for the trier of fact, whether the officer is being truthful today or whether his report is the best evidence of his truth. Those are questions of fact for the trier of fact, and in a manner tried by the jury, the court is not the trier of fact. I'm going to deny the motion for directed verdict, viewing the testimony and evidence in the light most favorable to the people, I believe they have, met their burden sufficient enough to sustain the motion. Anything further before I bring the jury back in?
No, thank you.
All right, you're bringing in the jury.
All right, so did the state rest? Because that's usually when you do a motion for directed verdict.
Instruction for- you can have a copy, you don't have to take.
See, this is why I have to check in with my chat, even on vacation.
Oh, yes, ready.
All rise for the jury.
Here comes the jury music. You know it's gonna happen.
Exciting and new.
All right, so the state rests, the defendants rest. We're gonna have some gripping closing arguments here.
All right, you may be seated. Are people ready for closing argument?
The people are ready.
All right, you ready?
Thank you.
Great.
Okay, ladies and gentlemen of the jury. As we come to the conclusion of this case, there are a couple things I want to point out to you all regarding the testimony of the evidence that people have provided to you. Now, you all heard testimony from Officer Law. Officer Law testified that he was dispatched to a home on Stone Street in Detroit. On his arrival, he came into contact with Mr. Clark. Now, his testimony indicated that Mr. Clark was outside with a couple of people coming to the side. And it's very important that you pay attention to the details of that, ladies and gentlemen, because it's going to be important as to your instructions that you all will receive when you go to it. Now, Officer Law came in contact with Mr. Clark, and Mr. Clark, as Officer Law testified, Mr. Clark had some sort of speech, he was unsteady with his feet, and there was an indication that there was some type of incident that happened between Mr. Clark and the individuals that were outside. Now, ladies and gentlemen, not only did you hear the testimony from Officer Law, but you all had an opportunity to view the video that was played in court, labeled as People Exhibit 1. And in the video, as Officer Clark stated, I'm sorry, I keep saying Officer Clark, Officer Law stated that he came in contact with Mr. Clark. When he came in contact, you all saw the video, and you all heard the audio, and you all saw the signs of this occupation in Mr. Clark. Now, ladies and gentlemen, as I stated before, nothing I say to you is evidence. All of the evidence that the people have for this case have been given to you, the testimony and the video. What I do want you to do is take that evidence and apply it to the jury. And ladies and gentlemen, it's simple. This is not a trick case, it's a straightforward case. And once you apply those elements to the evidence that you heard from the Officer Law, and the evidence that you saw and heard from the video, the people believe that you all will come back with a guilty verdict of conformity disorder person. Thank you.
Are we happy? Thank you.
Thank you, ladies and gentlemen, and I'm glad that we have completed the testimony for today. Now it is in your hands as the triers of fact. The trier of law, you guys are the trier of fact.
And
Oh, good Lord.
the facts that you guys get to make a determination on is essentially the credibility of that officer.
I'm willing to, I just don't know what
And while
happened.
we did see the video, recall what I asked you in voir dire. Is there something more in regards to intoxication? Hearing someone you don't know, you have no idea in regards to the level or the intoxication. Officer Law said, I observed slurred speech. I asked you as an officer to make reports about things that are important or relevant. Anywhere in your report, right after the incident, did you write anything about slurred speech? No. But after talking to the prosecutor, he made aware of what the allegations now are. Oh, I'm coming 9 months later and says, that's what I saw. If you saw it, why would you write? Why would you address it? Well, not only did I see that, Ben, but you don't know Mr. Clark. So you don't know how he talks regularly. You don't know if it has perception that you don't know what is going on with him. And you don't know. In regards to his inability to stand. I didn't see that. But more importantly, in regards to the officer's report, because really, factually, that's what we have to go on. I can come into court 2 years later and tell you the moon is green and I eat cheese off of it. But 2 years prior, when you asked me about the moon, and I have to make a report about it,
That
what are
might
we
be
gonna look
clippable.
at for the veracity of what occurred? What happened at that time? Was there anything stopping Officer Law from updating his report to these facts that for whatever reason, back in June of 2023, he didn't see it wasn't important, it wasn't of note to think about? He didn't.
Probably.
He didn't say anything about slurred speech. He didn't say anything about inability to stand. He didn't say anything about staying on topic. He didn't say anything about being a threat to anyone, harming anyone, including himself. He did not say that Mr. Kelly is of any individual. If it occurred, even in your investigation, while you're looking at everything or anything else, why wouldn't you mention the 9 months later, now that it's what this case is supposedly is about now? Oh yeah, I remember now. And let's just be honest. I don't know about any of you guys, but in regards to my memory, if I don't take notes, I might not remember yesterday. So how do we come in 9 months later and have just almighty clarity about things that you didn't write down? Hopefully address. The public policy and all that, that's great and wonderful, but bottom line is there are elements that people have to prove. One of the elements is that the defendant was in a tavern, grocery store, business place, manufacturing establishment, street, lane, alley, highway, or public building. On sidewalk. At a park, election, public meeting, where people are lawfully exempt. Private residence. He doesn't know if that field is part of that private residence. Secondly, that the defendant intentionally engaged in conduct that threatened public safety
violence to others, disrupted the peace, quiet of other persons present, interfered with the ability of other persons to perform legal actions or duties. You don't know if the person that called the police had a problem with Mr. Clark, because Mr. Clark did something wrong. Had an issue with that individual, and they just wanted him gone. You don't know. Because you don't have that testimony, and you don't get to guess. You don't get to say, well, I believe based on A and Q and L, that A, B, C happened. You don't get to do that, because those are facts, not emotions. You get to make a determination about facts. And you do that based on the officer's response, based on the little bit of video. He said it was a crowd of 2 or more. That he says was being held back, but yet, if he's being so disruptive and so irate and all of that, which again, he didn't know in his report, so 9 months later, why did he walk up to the police, walk around the individual that was trying to stop him from walking up to the police? Irate people, disruptive people, guess what they don't want to be? Involved with police. Ladies and gentlemen, it's not complicated. It's not true. People have a burden beyond a reasonable doubt, and that means, are there questions that were not answered by the testimony that was presented? And they're wrong. They have not met their burden beyond a reasonable doubt. And you don't get to do it in yourself. You don't get to guess or surmise or do 3.9, so I guess it's a 4. No, because we already know it wasn't a public place. We already know there was no intentional endangerment of the safety of another or property, because I asked the officer, did you see? Not what you heard, not what you were told. Did you see it? Did he present any of that to you? He did not. And therefore, that fact is not the evidence. Therefore, the people can reach their burden beyond the opportunity to go out. And therefore, Mr. Clark, not him, but the child, disorderly person, in public intoxication. And I thank you for your attention. Thanks, Susan.
Oh, sweet Jesus. What?
I have no idea what the hell she just said. Not one clue.
I need to see.
Is that it was just public intoxication?
Well, Where are you at, this thing now?
Okay. Yep. That's typical. Although this was bad. Like I thought, oh, this should be kind of interesting. Judge Bryant's presiding over it. Should be kind of fun. I was wrong. It was a swing and a miss. I not only did not hear their arguments, I can't even tell procedurally what's happening. And I know what I'm doing. Like, I don't know, did they just, it must be another sidebar. Usually, if they're going to give it to the jury, she would read them a little more instruction and everyone would stand up and the jurors would walk out. That's what I was expecting. Actually, I was expecting Ritter to say one more thing first and then that. But I don't know what's going on. You know, it's hard for me to say because I didn't hear anything. The sound may be a lot better in the courtroom, but all I heard was mumbling with the masks and that I could hear the witness okay, I could hear the video okay. I could hear the defense attorney better than the prosecutor. I didn't think it was great, but you know, it's hard for me to really judge since I don't. I to this moment I still don't clearly know what the charges are. The guy was sitting there. It looks like he was drunk and a little belligerent. I don't know exactly what they charged with or what the elements are. Despite having watched 85% of the trial. Yes, I am actually. In all seriousness, and even after I kept sneak attacking you with the Love Boat theme, I'm touched.
Exciting and new. There shall not be any cutting of trees. Don't cut any trees. I'll pass the order. No cutting of trees, no felling of trees in Patna number 12.
Okay.
We're back, baby.
Yes, sir. I know, so I keep on. I keep on asking you to go back there and then not waiting for you to set it back up. Okay, thank you. You may.
So ladies and gentlemen, my job here today is not to trick you all, but to use you all and see what you want. And based on the testimony from Officer Law, there was an initial run to this address for felonious assault. Officer Clark came into contact, I'm sorry, yes, Officer Clark came into contact with Mr. Clark. And upon his contact with Mr. Clark, he testified that he observed slurred speech and the conversation that went somewhere else that had nothing to do with it. Now, ladies and gentlemen, you heard testimony from Officer Law that at this point, he was fresh out of the academy, and that in the academy, he was taught about these indicators and signs of somebody who's been drinking or here. Now, ladies and gentlemen, I want you to confuse this all with the operating while intoxicated cases. That's not what I'm here today. I don't want you to get this all confused with the steps that an officer has to take when they come into contact with somebody who can operate while intoxicated. Okay? So that's not why we're here today. We're here because Officer Law was dispatched to his home, and when he arrived, he came into contact with Mr. Clark. And upon his observation of Mr. Clark, that's when he noticed Mr. Clark had been drinking here. Upon his contact with Mr. Clark, he noticed these other individuals holding Mr. Clark back on the sidewalk by the vacant lot. Now, ladies and gentlemen, assuming that you all live in the city of Detroit, everyone knows that it may be a burden on us to maintain the sidewalk, but if you're a homeowner, you know that that sidewalk is not your property, it still belongs to the city. You may have to upkeep it, you may have to shovel the snow, you may have to make sure your taxpayer dollars go to repair that sidewalk, but it's not your property, right? It still belongs to the city. Now, ladies and gentlemen, there's something we refer to in law as the best evidence rule. And that rule states that a writing, recording, or a photograph has to be shown as the best evidence in the case, because that's what it is, the best evidence. And ladies and gentlemen, the people did show you video. And without me telling you all what was the video, because you all have eyes, you all take the video, I'm going to ask you to look at this video one last time and use that common sense and everyday experience that you all have and that you all have encountered in your everyday life to come to your own conclusion as to what Mr. Clark's position was, his disposition as to what Officer Law came to comment. And after seeing this video one last time before you go deliberate, ladies and gentlemen, the evidence that was presented to you, the best evidence that was presented to you.
All right.
I'll help you determine that Mr. Clark is guilty of count one, the 30 person. Madam Chair, without the sound. The people will stop that video at 3 minutes, 29 seconds. Again, ladies and gentlemen, thank you all for your time. Thank you for serving us.
Okay, so it's drunken disorderly.
Ladies and gentlemen, I was trying my best to keep my word. I'm going to give you an option.
This is top-notch camera work.
Okay. It's 4:44 and it is going to take me at least 15 minutes to read the jury instruction.
Oh, good Lord.
So my question to you is, do you want to break for today or do you want to read these jury instructions? And I don't know how much time they're gonna give me in the building.
Go ahead.
Until they kick us out the building.
Yeah, we're the jury, they have to stand for us.
Okay, let's go, let me hurry up and read. All right.
No food.
Just keep going until they kick us out the building. All right.
All right, the jury wants to go. She wanted to kick it over till tomorrow.
Or until the court reporter says I'm listening. You can say if you want to. All right, members of the jury, the evidence and arguments in the case are finished, and I will now instruct you on the law. That is, I will explain the law as it applies.
Okay, this is a snooze fest, but here's the deal. I'll probably just leave this open until we get the freaking verdict, because I think they're gonna come back in 2 minutes. A jury that wants to stay wants to be done. I don't know what the verdict is, but I think this jury.
Remember that you have taken an oath to
one way or the
return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of the case are. This is your job and nobody else's. You must think about all of the evidence and the testimony and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in the case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer has said something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all of my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum it up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of the case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of the witnesses, the exhibits admitted into evidence, and anything else I told you to consider. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. The lawyer's questions to the witnesses are not evidence. You should not consider these questions. You should consider these questions only as they give meaning to the witness's answer. You should only accept things that the lawyers say that are supported by the evidence or by your own common sense and general knowledge. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide the case, please pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all of the evidence regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during the trial. As I said before, it is your job to decide what the facts of the case are. In deciding which testimony, you do not have to accept or reject everything a witness said. You are free to believe all, none, or a part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experiences. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on the race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may help for you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that may have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act when testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness have any bias, prejudice, or personal interest in how the case is decided? Have there been any threats or promises, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the evidence in the case? Sometimes the testimony of different witnesses will not agree. Oh, that's not applicable. You may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proven by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. You may consider circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence you believe. Her testimony from a witness that was a police officer. That testimony should be judged by the same standards that you use to evaluate the testimony of other witnesses. The prosecutor must prove beyond a reasonable doubt that water. Okay, thank you. The defendant is charged with the crime of being intoxicated in public and causing a disturbance or endangering persons or property. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant was in a place open to the public. Second, that the defendant was intoxicated. A person is intoxicated when he or she is mentally or physically impaired as a result of consuming an intoxicating substance, such as an alcoholic beverage or other substances. Third, that the defendant directly endangered the safety of another person or property, disrupted the peace and quiet of other persons, interfered with the ability of other persons to perform actions or duties permitted by law.
That's the
hard part. The defendant is charged with disturbing the peace. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant was in a tavern, grocery store, business place, manufacturing establishment, street, lane, alley, or highway, or public building,
Got
at
that.
a park, an election, a public meeting where people were lawfully assembled. Second, that the defendant intentionally engaged in conduct that threatened public safety, threatened violence to other persons, disrupted the peace and quiet of other persons present, interfered with the ability of other persons to perform legal actions or duties. The defendant must have intentionally engaged in conduct that went beyond stating his position or opinion or the mere expression of ideas. The prosecutor
probably
must also
supports that.
prove beyond a reasonable doubt that the crime occurred on or about June 18, 2023, at or near 16546 Stokely Street in the city of Detroit within the county of Wayne. When you go to the jury room, you should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a business-like manner and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own and you must vote honestly and in good conscience. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me in the jury room, while you are in the jury room, please have your foreperson write a note, put it in an envelope, and give it to the court officer. It is not proper for you to talk directly to the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return a unanimous verdict, do not reveal this to anyone outside the jury room. That means if you're deliberating and your vote is tied or, you can't reach agreement, just send a note saying we can't reach agreement. Don't send a note saying it's 3-2 or that don't add up to 6. Don't put the numbers in the note. Just say we can't agree, okay? If you want to view the exhibits, which it was only one, you're gonna have to come back in the courtroom because I don't have a way of sending that video back to you. I am giving a copy of the instruction, and normally every juror will get their own book, but as I indicated earlier, Ms. Pillow is not my regular court reporter, and normally my court reporter would get the jury books together, so I'm only gonna send one book back. I tried to make sure that it was up to date. So I'll send that one back, and then you may return a verdict of guilty of the alleged counsel approach. I forgot to ask this question.
I have a dress shirt and boxers on here.
All right, you may return a verdict of the alleged crime, or, I'm sorry, you may return a verdict of not guilty or guilty of the alleged crime, and the court is providing a verdict form. The only person that needs to fill out the verdict form is the foreperson. You're gonna date it, print your name and sign it, and it just reads the case caption, and then we, the jury, by unanimous decision, find the defendant count one, either not guilty
That seems
or
about right, Leslie.
guilty of disorderly person wrong. All right. I am gonna pull two numbers. And this is the way I do the alternates now. Due to, since COVID came about, and plus other emergencies, I'm gonna pull two numbers. These individuals are going to be free to leave. However, if the jury does not reach a verdict today, we may have to call you. If the jury doesn't reach a verdict today and something happens to one of the jurors, the two that I'm calling, you're still alternate. You're still on call.
These people do not want to come back. I don't blame them. It's a smart jury already.
We're gonna thank and excuse juror number 3. Please write your telephone number on, the somewhere.
Yep. Looks like they set 8 for a 6-person jury.
We're gonna thank you. Look, I'm sorry, y'all. I was looking at the jury's face, they like, pull my number.
All right, that's a good idea. Let me see if I can do that.
Somebody really needs to know. I can't do it that way. I can't ask for volunteers, can I? No, ma'am. Okay. And we're gonna thank and excuse juror number 1. Oh. Ms. Ritter. Write your phone numbers down, please. All right, it's 5 o'clock. I don't know when they're gonna, kick us out of the building, because I think I only got permission to stay, till right now, but I'm gonna call upstairs. I'm gonna send you to the jury room. And then Officer Bennett, come on. Then I'm gonna see what they say. So just work until we're not gonna. Oh, juries.
All right, so the jury.
Any objection? All objections.
Oh, man, I gotta get together.
All right, well, there you have it. We're just going to wait around. I don't think it will take them very long. It's interesting. I couldn't figure out what's going on just because the sound quality is so bad with half the people who are talking. You certainly could have a verdict come back either way. I think that the state has more than enough for conviction. However, in both cases, there's a sort of a drunken disorderly, there's sort of a public intoxication and then sort of a disorderly conduct type charge. Both of them have an element where you have to annoy somebody else, and that's the most subjective thing. So I could see a jury saying, no, he didn't, yeah, he was clear. He was in public and he was drunk, for instance, on the public intoxication type charge. But did he bother anybody else? It appeared he bothered the one guy. The one guy was trying to hold him back because he was being obnoxious. The one time we heard the video where he was talking, he was pretty darn obnoxious. Not the most egregious thing we've ever seen, but I think certainly enough for the elements of the offense. If I had to guess, they're gonna ring him up on at least one of them. And but this jury, she's like, oh, do you want to go home? Because they're all like, hell no, we don't want to come back tomorrow. We'd rather be here till 5:30 than get up tomorrow morning, put pants on, and come back to the 36D. I'll tell you that right now. So that's where we are. Let me see. What's our poll doing? Our poll is strong in the conviction department. That makes sense. I could also see an NG here because like if you have some like people who are really like really sort of hate the police, anti-authoritarian effectively, which is fine. If you have any of that strand, I can totally see not guilty here. Not because they didn't really make the elements, but because it's not the most egregious bit of conduct you've ever seen. So there you have it. All right, I'm going to get off. I'm going to get off the screen here, but I'm going to hang around here until they come back within reason. I mean, I don't think it'll take very long because they don't want to come back tomorrow. And she put pressure on him, said, I don't know how long it is till they kick me out of the building. Her whole thing is, I don't care. I already have to come back tomorrow. I want to go. She didn't want to give it to the jury. I don't blame her. I'm not knocking her. But she's like, I want to go have dinner. The jury's like, we don't care about your dinner, Judge. We care about not coming back tomorrow. It's very simple. She was good-natured about it. She said, all right, fine. She read him the jury instructions quick, gave him the case to take back to deliberate on. I'm thinking 15, 20 minutes from now, and we've got a verdict. My guess is a guilty on at least. My guess is a guilty on the public intoxication, and they kick the other one to do the guy solid. That's my guess. But literally, any verdict here is justified. I can absolutely, as a matter of law, justify all guilty, all not guilty, or a split. Easy, in my mind. So we'll see. At least as she read the jury instructions, I finally figured out what the hell the case was about. After the case was over, when she's reading the instructions to the jury, I finally like, oh, those are the charges. All right, I'm here. I'm chilling.
Ma'am, are you a whore?
I object to the relevance of that, Your Honor.
All
right. What?
I'll tie it up real quick, Judge.
All right, go ahead.
You're not a whore?
Oh, sweet Jesus. What?
Ma'am, are you a whore? You're not a whore? Not a whore? You're not a whore?
I never want to hear it again. Sweet Jesus.
You're not a whore? Not a whore? You're not a whore?
I never want to hear it again.
It gets worse.
There were drugs involved that were given to me that ended up being glue. Like I smoked some glue and stuff. I thought I was smoking crack.
Let's go.
You didn't say the cat jumped on his wiener, did you? Sit down and shut up. Shut up. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up.
Can you just let this go for once? For once? Once?
Okay, that being
Sharps, Mr. Sharps, Mr. Sharps.
You're not a whore? You're not a whore? I never want to hear it again. You're not a whore? You're not a whore? I never want to hear it again.
Now, if anybody thinks this is okay, I am in the wrong. Freak trial. This is crazy.
Ma'am, are you a whore?
Okay, I need a thumbnail and a title for this. I'm thinking Trial of the Century. If you guys have any good ideas, let me know.
exciting and new.
It was all a dirty, evil love boat plot. Oh, hey now. I'm getting verdict vibes. I think Lunice is warming up.
Oh, and again, I know YouTube is mad at me because I had it on mute, and I didn't unmute, but, Mr. Clark, congratulations, please, sir. Miss, Taylor Coleman, please just fill out a dismissal form. I will sign the dismissal. And then, sir, you can wait in the hall for the dismissal. And then can the prosecutor and the OIC also step out? I'm just gonna talk to the jury briefly.
Do you have a fingerprint motion also, Your Honor?
Yeah, it should, the one that you.
What happened? I don't know what happened. I know you're looking to me. She's asking for a dismissal form that makes no sense to me whatsoever. We tried the case. It went in for verdict. Why would the prosecutor dismiss the case at this point? Wind it back a bit. She didn't have her microphone on. I heard it from as soon as she got her microphone on. They deleted it from YouTube? Well, that's just a perfect end to this shit show. It's a perfect end. Some quality time with Law Talk with Mike. Everyone's left hanging. There's no happy ending here, people. You know what it reminds me of? You'll never guess what it reminds me of. It reminds me of this.
Love, exciting and new.
You think it's going to be good, but it sucks. Oh my God, I've lost my mind. I've had some bad streams. I've had some horrible streams. This is so fantastically awful. I did not do it. I did not do it. Take it up with the 36D. All right, somebody will get the verdict. I'll put it in the community tab or something. So there'll be a disposition. You can look it up. It's not there yet, but there will be a disposition that'll go into the court system in Detroit. I've got Detroit attorneys in the group. Someone I don't know what to do with this. I don't know what to do. I don't know how to dig out of this hole. Here I am. We sat through the whole thing. I thought I'll see it through. I'll see it through to the end. I will see it through to the end. And there you have it. Somehow we have a mystery dismissal. When I first heard that, I thought, okay, that's another case that was on the call today, because it makes no sense in this context that you'd have a dismissal. You're going to have a verdict. Guilty or not guilty. Why are you having a dismissal? If Christina Ritter had a change of heart and thought, let's dismiss the charges, why wouldn't you do that prior to the trial? Unless there was some bad thing. That something might have happened with the jury, or that somebody knew somebody, or there's some it's either that or we have to call a mistrial. I don't know. There's an explanation for it, but it's certainly not what I expected. All right, I apologize. Thank you all for hanging out with me. I don't know. I'll probably just take this thing down. I don't know. It's cocktail hour here. It's cocktail hour here in the land of sun. I literally just did this stream to get out of the sun. As you can see, I've had enough for the day. But it's cocktail hour, people. Thanks for coming out. I'll see y'all soon.